Welcome. This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation. Thank you. So I will get us started. Good afternoon, everybody. My name is Katie Jones with ADR Services, Inc., and it's my great pleasure today to present our program, Behind Closed Doors, Inside a Mock Mediation of a Landlord-Tenant Dispute. Now, without any further ado, I would love to introduce our mediator, who will then introduce our counsel for this program. So I would love to introduce Ms. Debra Bogaards. So Debra is a seasoned mediator with over 5 years of private mediation experience, 6 years now, and almost 30 years as a mandatory settlement conference officer in San Francisco and Marin counties. She holds a remarkable track record of a consistent settlement record of over 98%, and having gained a balanced perspective after representing both plaintiff and defendants through her 40-year career, her expertise includes a wide range of employment issues, personal injury matters, elder neglect, abuse, and most relevant today, landlord-tenant disputes. So thank you very much for joining us today, Debra, for leading us off as our mediator, and I will turn it over to you to introduce our other speakers.
Thank you so much, Katie, and a shout out for her birthday yesterday. All right, it gives me great pleasure to introduce my 2 co-panelists. First, Jacqueline or Jackie Ravenscroft. Jackie is a partner at Tobiner Ravenscroft LLP here in San Francisco. She is a graduate of my alma mater, UC Law, San Francisco, cum laude in 2011. She is a wonderful tenants' right lawyer who advocates for the basic human right to safe and stable housing. Welcome. Next, I'd like to introduce Erin Poppler. Erin is a partner at Edlin Gallagher, Huey & Blum. She is also a graduate, that makes 3 of us, from UC Law SF, graduating in 2009. She is a trial attorney specializing in environmental litigation, as well as large residential buildings where she represents the owner or landlord. So welcome, Erin.
Thank you, Debra. Great to be here.
In a few minutes. Good. I'm going to quickly go over the landlord-tenant mock mediation fact pattern found in your materials. Former tenants Carol and Jessica are suing the owner and landlord, Olivia, for claims arising from habitability defects, tenant harassment, and a loss of rent control department. For most of Carol and Jessica's tenancy, Carol is a single mother working full-time as a hairstylist to support her family. Her daughter, Jessica, has suffered from extreme anxiety and agoraphobia for many years. Jessica's fears of strangers and extreme anxiety made it difficult to allow repair workers into their apartment, contributing to the issues they experienced. Carol and Jessica lived in the rent control apartment in East Oakland from 2017 to 2022, so 5 years. Nearly 7 years ago, after her mother fell ill, Olivia took over managing the apartment complex. She also lives in the building itself, which she believes allows her to be more responsive to tenant issues. The apartment complex was built in the 1960s, and as you can imagine, it still has the original plumbing and windows and insulation. Carol and Jessica have complained of a myriad of habitability issues during their tenancy, including trash and debris piling up in the common areas due to criminal activity, a broken window and a bullet lodged in the wall, a broken gate allowing unauthorized individuals to have access to the backyard of the complex where they've had tent encampment, fires, and so forth, a gaping hole in the kitchen floor, no shower or bathroom for 3 weeks, and they couldn't afford to go to a hotel during that time and were just running into public restrooms and so forth. Can you imagine? Missing and unevenly installed shower tiles, water leaks, plumbing leaks, and windows that leaked during rainstorms for more than 2 years, leading to excessive dampness and mold growth and causing Carol extreme asthma attacks. And lastly, the flooding and rats and mice. Olivia has been unsure of how to manage problems arising from the neighborhood elements. After the pandemic began, neighborhood around the building started to decline due to criminal activity emanating from the nearby park. Some of this spilled over into the apartment complex, including the dumping, tent encampments, and so forth. Carol operated a small hairstyling business out of the apartment, which was in violation of her lease. The unapproved installation of a professional shampoo bowl in her apartment with old plumbing led to the flood that caused additional water damage in the apartment. Olivia claims that the unauthorized modification contributed to habitability issues, including mold and further problems. While Olivia tried to address other repair issues, her efforts were often delayed due to Jessica's anxiety and her unwillingness to allow in people to do the repairs. Olivia claims that she made several attempts to coordinate repairs, but was met with resistance and delayed access. Carol claims that Olivia often let herself in or aggressively banged on the door, demanding to enter the tenant's apartment without notice or lawful purpose. She also would make comment over Jessica. The intrusions exacerbated Jessica's panic attacks, even leading her for emergency medical treatment. At one time, Carol said, "What is wrong with Jessica? Why is she so weird?" During the last year of Carol and Jessica's tenancy, Olivia repeatedly told Carol, "If it's so bothersome for me to not follow tenants' rights, then you should just move. Come on, just move out." As a result of the building's conditions and the strain of living in a declined neighborhood, Carol and Jessica did decide to move out. The family relocated to a more expensive apartment, 2 bedrooms and 1.5 baths, in a better neighborhood in Oakland. Olivia questions whether there were financial considerations or a desire for better living situation for the move out. We're at the end. Carol is seeking the following damages: 50% of the rent paid in the last 2 years of tenancy, future rent differential, trebled, moving costs, trebled, personal property, emotional distress, trebled, which comes out to $900,000 alone, the FIHA violation, attorney's fees, and costs during trial. Her damages in her mediation brief total almost $1.5 million. However, Olivia's insurance policy limits are $1 million. This mock mediation is occurring after suit is filed and before the parties begin discovery. So with that, let's get started. The first thing we're going to do are some pre-mediation phone calls. Typically, I like to do those individually with counsel the week before, maybe after I have a copy of the mediation brief. In complex or multi-party cases, sometimes those are better to have a month or more before. In our mock mediation, counsel who is not participating will turn the camera off so we won't confuse the audience. So let's begin with the plaintiff's counsel, Jackie.
Hello, Deborah. Nice to hear from you today.
Oh, well, good afternoon. I wanted to talk to you. It was an excellent brief. Is there any reason why it's confidential, given that if we were to let Erin see it, I believe she would be able to share it with her clients and expose some of the strengths of your case?
I think that's a good point. And, I'm not opposed to sharing my brief. I know this firm typically submits theirs to Mediators Confidential. So I was just hoping that, you could have the same conversation with them. I'm happy to share everything in the brief, and hopefully, that would get them to share their brief as well.
Excellent. And I think that's a great idea. I will be talking to Erin about sharing her brief too. I never understand why all of it has to be confidential. Maybe certain segments can be taken out.
Yeah, in the future, if Erin agrees, in the future, I'll make all my briefs to her firm not confidential. I think it's useful for everyone to see that in advance of the mediation, and I apologize if that's making your job harder today.
No, not at all, not at all. But you know what would make my job easier? Let's talk about evidence. Do you have any photos of the habitability claims, maybe an iPhone video walkthrough of the apartment before they left, and receipts? Maybe it's from a credit card or bank statements or actual receipts for the personal property.
Yeah, I have several photos of the habitability conditions while they were living there. I believe we have a walkthrough video as well. There's not a whole lot in terms of receipts, and although there are claims for property damage and moving expenses, those are pretty nominal compared to the bigger damages we're claiming in this case. I think they're around 6,000 and then trebled under the ordinance. So there's receipts for probably a few thousand of those, but most of them are furniture that was ruined by the mold or the water intrusion that my clients just had to get rid of. And so unfortunately, there's not a whole lot of that. And then in terms of documentation, complaining about the habitability issues or documenting the harassment, Olivia lived in the same building as my clients, and at first, my client and Olivia were friends, so a lot of it's verbal and in person. As I mentioned in the mediation brief, I do have a few witnesses that I've spoken to and who have given declarations and would testify that they overheard a lot of these comments, kind of telling them to move out, I can get more rent from somebody else. But unfortunately, we don't have a long text chain of all of those.
But that would be great if you could even supply me with some of the declarations from witnesses.
Sure.
They can even be informal. If you just get them to handwrite something,
Yep.
that would be enough for me to share with defense.
Okay.
Thank you. You just touched upon something I was curious about. You were talking about harassment. And so I want to know how we can frame your claims, because I understand harassment is not covered under the policy, but negligence is. Is there a way we can do that?
Yeah, I talked to my clients about this, and I think that's one of the things that will come up today is, in their mind, this was very targeted. This is disability discrimination, it's harassment. And between you and I've tried to explain that for today's purposes, we're kind of walking a fine line and reframing that as negligent self-management. And in my brief, although I included the harassing acts, the title of that paragraph is something like negligent self-management of the property. And, she negligently trespassed, and she negligently said these comments about the rent, and she negligently gave them essentially verbal eviction notices without just cause. So I think that the carrier will have a hard time arguing that none of this is covered, because she is a woman who, although she owns this property, she inherited it, the landlord, she inherited it. I don't think this was done while reading the rent ordinance and saying, I know I'm violating this intentionally. So I think that would be a hard position for the carrier to take in terms of like bad faith coverage with their insured.
I like that. We just mentioned another topic that I want to discuss with you, coverage. Are there any coverage issues with the attorney's fees?
Yes. So overall, the policies I think are quite good in that they cover essentially all of the claims here. They cover bodily injury, property damage, and most importantly, wrongful eviction, which I think is the outside of emotional distress, the driver of some of the damages here and the path to attorney fees. But and there should also be a policy that maybe covers mold. I haven't seen that from Erin, but she mentioned something about a pollution policy. So that's good. The not good thing is that the policy that I have seen does not cover attorney fees. And, blackboarding the damages, the attorney fees are, and the amount of time this trial is going to take, I think the attorney fees could be, in the 300,000-400,000. And there's several paths to fees here for plaintiffs, FEHA, the Oakland Tenant Protection Ordinance, the Just Cause Ordinance. So I think that landlord Olivia has pretty big personal exposure here that hopefully has been explained to her. I don't think she has personal counsel here, but if not, maybe, that's something that can be discussed in that room today.
All right. I like that. Lastly, let's discuss any weaknesses that that we both see that you can tell me about, such as the obvious one,
Mhm.
your client, which I understand after the pandemic, you couldn't work out in public. So she installs a professional shampoo sink in the apartment, but with the old plumbing, I understand that is the cause of the flooding, which is also one of the elements of her habitability claims. How do you want to handle that?
Yeah, I mean, I think there's a few things that should be shared with that. You know, as I mentioned, Olivia and Carol were friends, pretty quick, fast friends upon move-in. And during the pandemic, you know, they really started hanging out even more. And Carol lamented with her how financially hard the pandemic was, and talked to Olivia about bringing people to the home. And Olivia never expressed any objection to that. I understand Olivia's claiming she didn't know, and she didn't know about the sink. But I think that that will be difficult considering their proximity and friendship for her to prove. But the bigger picture is that the sink is one small element of the habitability claims. Yes, there was a one-time flood. You know, it took longer than it should have to get fixed, and my clients were without a bathroom for a long time, several weeks, during the pandemic. But really, there's so much more here in terms of the habitability and the negligent self-management and the FEHA violations that I don't think it's a big deal. I think it's something that I'm sure Erin's side will bring up at trial, but I don't think a jury is going to let that outweigh the gravity of the other issues, including, you know, broken security gates and rats and mold throughout other parts of the home and a leaking roof. I mean, you can't have a leaking roof and leaking windows and then say all the mold's from one plumbing flood.
Maybe between now and the beginning of mediation, we can either talk again, or you can send me, or if you know right now, some sort of apportionment over what percentage is due to mold, since I know that probably has separate coverage in Erin's room. What percentage is due to the shampoo sink, what percentage to the, you know, broken security gate and so forth.
Sure.
And it might be helpful in the defense room.
Okay.
Great.
I can work
Is
on
there
that.
anything else that I haven't asked you during our brief pre-mediation call that you think would be important for me to know?
You know, I think that during the mediation, you know, my clients have strong feelings about this. I'm sure Olivia does too, because of the history there of being friends, and then kind of like this meteoric like crash in their friendship. And my client feels really betrayed. And so that's something that, you know, will probably play into our session.
Well, so that brings up another really good point. I think what we should do is a staggered start time. I know this is meant to be in person, so maybe I'll have the defense arrive like 45 minutes later. Does that sound
Great.
good? Put
I
them
think
on
that's a
opposite
great
end.
idea. Yeah,
Okay.
and I'll be on, you know, hallway bathroom lookout to make sure they don't run into each other unless that's going to be the case.
That sounds great. Okay.
Okay.
Thank you so much. I look forward to seeing you at the mediation.
Okay, talk to you
Feel
then.
free to just send me the documents any way you want, right?
Will do. Thank you,
Okay.
Debra.
Thank you. Bye. So now I'm going to walk into Erin's room. Hi, Erin.
Hello, Debra. Good to speak with you.
Good to talk to you today too. So why don't we just jump in? What I'd love to talk to you about is plaintiff's counsel, Jackie, is amenable to producing her otherwise confidential mediation brief. If you would also be so gracious as to produce yours to her, I think it would be a good idea, because you bring up a lot of really good points that I believe Jackie would need to discuss with her clients before the mediation. What are your thoughts?
Debra, I'm very open to that. We received the confidential brief from Jackie, and we also, as you saw, marked ours confidential. The one piece that we would hold back is there is a discussion of insurance in the brief. We'll share all of the brief, but for that section on insurance, because what I don't want to have happen is for Jackie to start thinking and reframing her claims in order to trigger coverage. But with that said, the rest of the brief can absolutely go. And I appreciate you bringing that up, and also Jackie reciprocating by sharing her brief with us.
Great. All right. So I'll let you redact the portion that deals with insurance, and then you can send maybe a new copy to me as well as to Jackie on the same email. So how are you doing with opposing counsel? Any obstacles? You're getting along?
I really appreciate you asking that, Deborah, and we're doing very well. You know, I think we both come from the place of we can disagree without being disagreeable. And as you've probably seen by reading our mediation briefs, we have diametrically opposed views of what is actually going on here between Olivia and Carol. But with that said, we've been working well together leading up to mediation. My hope is that that's going to result in some reciprocity when we do get to the mediation.
Just like bullet point, what are your diametrically opposed views?
Our position is that Carol's installation of the professional shampoo bowl in her unit is really problematic. Not simply for the fact that that was in breach of the lease, as was running a business from what the lease said could be a residential home only. It caused a major flood that affected her unit and the downstairs unit. Carol's insurance is Olivia's insurance has already paid over $100,000 of property damage to fix that flood. It's bigger than that though, Deborah, because the issue with running the illegal hairstyling business out of the unit led Carol to not share with Olivia the complaints that she's now brought to life in a very public lawsuit against Olivia, because she didn't want Olivia to know that she was illegally using the apartment for hairstyling. And as we know, notice is a requirement in order to recover for many of these habitability claims. Carol also signed an addendum in the lease informing her about mold and the importance to give immediate notice if there were any leaks or other visible water absorbed. Well, when we came in for the emergency repair for the shampoo bowl overflow, the plumber's report, the technician's report indicated that it had been leaking for quite a while because that volume of water used by the bowl was just too much for the building to support. And that certainly dramatically contributed to the alleged mold issues here.
Oh, one quick question on that. In your brief, I read where Olivia and Carol had been at least friends or very good friends, and that your client would go into the apartment, maybe unannounced, often, maybe as friends do. Didn't Olivia notice the professional shampoo bowl and clients coming in and out way before the flooding?
And it's a very important point, Deborah, about the underlying relationship, which wasn't highlighted in the facts that have come to life so far. Absolutely, they had a good relationship. And because of that, Olivia would go to Carol's apartment, would knock on the door, would have conversations. She wasn't trespassing. That was the dynamic between them. But did Olivia know that there was hairstyling clients coming to Carol's apartment? She didn't know. Should she have known? Possibly. But this was never something that was disclosed to Olivia by Carol.
Okay. Hard to not notice when women or men leave the apartment looking particularly wonderful from hairstyling. I guess a more difficult question, do you have insurance issues in your room?
Deborah, do we ever? I'm so glad you asked it. We have both uncovered claims as well as a dispute about what claims are covered. And it's so important that this is not simply a linear discussion as between myself and Jackie and my client Olivia and her client Carol, because on my side, I have coverage disputes happening as well. We know we have attorney's fees, we have the tripled penalty. None of that is going to be covered under the policy. We also have this harassment claim, which also won't be covered. When we shift to the claims that would be covered, we have a general policy, as I shared with you in the brief, as well as a pollution policy. And the difficulty for the carriers is that it's not clear what damages and habitability problems track to which issue. For example, if it's just a flood, that's probably a GL policy. But if it's a mold issue, that's the pollution policy. And although I am here as defense counsel, I feel it's very important for me to alert you to the fact of these coverage disputes so that doesn't become a major hurdle for us moving forward on the day of mediation.
Oh, good. So to get ready for the day of mediation on those issues, I have asked Jackie, plaintiff's counsel, to provide me with her client's apportionment of what is mold and what else, so that you can determine what is covered. But are there other ways I could do that, or information you need to make an allocation as to mold damage, flooding, etc.?
Jackie and I have been working well together and exchanging information. I can identify one of the issues that we've not received robust or any information on yet is daughter Jessica's past medical records, and specifically any therapy records that she may have had. As you know, the lion's share of the claims here is this $900,000 emotional distress piece. So the pre-existing condition for us is certainly something that Carol and Jessica have opened the door to, and we believe that we are certainly entitled to those records.
And have they not been forthcoming? Is there a resistance to giving you these records?
We have had a dispute about how far back we're entitled to see these records. And so if you could assist with that early on, I think that that would be very helpful as well.
I would be happy to. Before we conclude, who will you be bringing to the mediation in terms of other defense counsel, coverage counsel? I want to make sure we have the right parties and attorneys present.
Certainly. And we will have a large room on our side. I will obviously have Olivia, and I want to share with you as well that although Olivia has been advised to get coverage counsel for the very issue we've discussed, covered versus uncovered claims and her own personal exposure, Olivia has decided not to have coverage counsel. So she won't have coverage counsel with her. I want you to be aware of that. We will also have representatives from several insurance companies who will have decision-making authority, and they will be in the room as well. Now, I want to share with you something about the personalities. There are some strong personalities in this group, and that's why far in advance of us sitting down in a mediation, I thought through who the best mediator would be for this case, given the personalities of the folks in my room. And so I think you're going to be able to be both facilitative and straightforward with them when the time is needed. But just be aware, we have a mix of personalities, some very strong ones on the insurance side, and we have Olivia without coverage counsel and also feeling very defeated by the situation that's developed with Carol, but also adamant that her name has been run through the mud through this lawsuit. And if she has to go to a trial to clear it, she's willing to.
Well, thank you for the vote of confidence and all of this good information. I know that we'll have our work cut out for us to make the magic happen. I will see you at mediation. Thank you.
I look forward to it. Thank you, Deborah.
Okay. And with that, we're now going to switch in time to an in-person mediation, although it's by Zoom for this purposes. So while Zoom mediations account for the majority of all mediations and are equally effective, I believe that in-person mediations have some advantages. First, they assure commitment and being present, literally. There are no distractions. You don't have counsel simultaneously doing 2 mediations at once, which I've had, or preparing a brief or law in motion at the same time they're in mediation. So they really are present. 2, you can schmooze over bagels with a schmear in the kitchen with opposing counsel, which humanizes the interaction. 3, I literally can slow things down more easily when counsel needs more time. For example, one time I had a very stressed counsel with the room that Erin's describing, and in my stilettos, I walked to get coffee and make them a lot of tea, and that takes time, and so there was no burden on the counsel to go faster in coming up with the next offer. 4, it's a good way to showcase your plaintiffs. If they're really good, then defense in the nice fishbowl rooms will see them walking to the kitchen or down the hallway, and in a natural state, they can see that they have a very nice presence and will be likable to a jury. 5, it's more conducive for a public apology. Yesterday, I had an in-person mediation where the plaintiffs really needed a public apology or private, and that could be done easily. 6, in the event that the case doesn't settle, the connection has been made to make discovery easier between counsel. All right, in our mock mediation, clients and decision makers are not going to be in the room with lead counsel only due to the time constraints of this mock mediation. So let's get started. Okay, we're going to start with tit for tat negotiations with counsel. And this also has a name called the dance, and another neutral likes to call it the haggle waggle. But basically, it's where we're going to go back and forth getting a settlement demand or a settlement offer, hopefully with a justification. So I'll go first into Jackie's room. Hi, Jackie.
Hello.
Good to see you. It's time for us to get your first settlement demand on the table. Go ahead.
Yeah, so we're going to start at the $1 million policy limits. Demand as our opening offer. You know, I think that the damages when you account for the troubling, the emotional distress, and the attorney fees are above $3 million. I think starting at $1 million is more than reasonable, and the carrier has a lot of exposure, even though we've talked about some of the uncovered claims. So that's where we'll be starting today.
All right, thank you. I will come back to you. So next I'm going to go into Erin's room. Hi, Erin. So I have a first opening demand from plaintiffs of the $1 million policy. That should be no surprise to you. I think it's a reasonable place to start. I'm not too hard on people on their first numbers. I just like to get them on the board. So could you share with me, please, from your room, what will be the offer? And I know you've had some time to do so before I walked in.
Yes, certainly, Deborah. I will just pretend that I've been discussing this for a while. Thank you for conveying the 1 million policy limits. Maybe not a surprise, but certainly is disappointing to our room, given what we believe are the very strong defenses that I highlighted for you when we had that very productive pre-mediation call. The other issue remains the uncovered issues. The triple damages are what are getting Carol's damages so high. That's really a penalty, though. That's not going to be covered by insurance. And the more that Jackie and her client push that button, they are going to have to show intent and gross negligence. That also gets this out of coverage. And so it's our position that the damages are not going to be tripled here, period. With all that in mind, and what I've already shared about issues with the illegal installation of the bowl being the major issue here and not giving notice or sufficient notice of other issues, we are going to start with $50,000. And I want to send a message that to Carol and Jackie that we believe strongly in our defenses today, and it's still early, but they need to understand our position and where we're coming from.
Okay, I appreciate that there's been a lot of thought put into that. It's very low. I'm not sure the reaction I will get in the other room, but I will go ahead and take that to them. I would hope that on your next move, you can come up substantially, because I know just with the rent differential, it makes up almost that number, but I'll be back. Thank you.
And I appreciate it, Deborah. Thank you.
Okay. All right, Jackie.
Yes, hello again.
Hi there. So I had a long discussion with defense counsel Erin Poppler, and you know from the brief, because now you've seen their now non-confidential brief, that they have a completely, no surprise, different view of a lot of the damages. Erin mentioned to me that much of the damages that you have trebled, the trebling is not covered by insurance. And from what she's been telling me about Olivia, other than having this property, which is, by the way, highly mortgaged, even though she inherited it from her mother, the cost to fix the old plumbing and everything that's original, she has made her out to be someone who's a little bit less affluent than we thought. So
Okay.
a lot of the damages looks like they're not covered. They'd have to come from Olivia's pocket. And she has a different view. So I tell you that only because I think that the opening offer is on the lower side, but I'm sure that it will get a little bit larger. So she's offering you $50,000.
Yeah, obviously you're right. Your instincts are great on this. I mean, that's barely covers even like one line item of damages, and the smaller line item of damages. I think that it is worrisome to me because I think this case is like worth in the high six figures, between you and I. And I worry about that. I also worry that it sounds like Olivia doesn't have personal counsel. And obviously Erin's hands are tied in talking to Olivia about her exposure. So, if it doesn't settle at mediation, I would hope that Erin introduces the idea of personal counsel for Olivia, which I have no doubt she already has. She's a very ethical lawyer. But, she may have to pay something out of pocket, and that's I'm sure an uncomfortable position for Erin to be in, for you to be in. But I know you've had many mediations where individuals have to pay out too. So I think it's too early to talk about that in the other room. But really at this point, I'm just gonna match her and move down 950 because I'm not sure that they're really here in good faith with that opening.
So you're moving down by 50,000 to 900,000?
Yeah, 50,000.
Okay.
To 950.
Okay. I can tell you that she doesn't have coverage counsel, which is very disappointing. I believe that Erin Poppler wanted her to have coverage counsel.
Mm-hmm.
The good news is that I can go in the room and she's given me latitude to talk to her directly. So
Great.
As mediation progresses, I will have an opportunity to talk directly with her about some of the weaknesses in the BATNA here. I do note that with the 50% of rent paid in the last 2 years of tenancy, those are your habitability, discrimination, nuisance, and trespass claims, you've itemized $19,032, and that the future rent differential, of course, that's treble, is $96,000. So it seems that their corresponding first offer is very low. It doesn't even cover that. But again, I'm not really hard on people while they're just getting numbers on the board, like I said. So I'll take your $950,000. I would like to see you, however, make a larger move. You don't have to always match them tit for tat. Like I tell my students, I'd love you to invert, think what's it going to take for them to say yes to this mediation, but I will be back. Thank you very much. Now I'm going to go back into Erin's room. Erin, hi. So had a good conversation with Jackie. She's underwhelmed by the initial 50,000 offer, like we both kind of expected. And the reasoning simply is that, as we both know, her initial items of damage, which are the 50% of rent paid in the last 2 years of tenancy, that's about $19,032. Then she has her future rent differential, and even without trebling, that's another $30,000. So that is a little bit more than the 50,000 initial offer. Unfortunately, she only came down to 950,000 because she really believes that her client is going to prevail. And so I would hope that you will be able to come up much higher so that you've included some money for the emotional stress damages. What do you think?
Sure, Deborah, thank you. It's early in the day. I appreciate Jackie making that move. Again, as I said from the top of the meeting, we were surprised to see this start at $1 million. So our thinking is not going to be anchored by that number. I think that the rent differential damages have been brought up a few times now. So I do want to speak to that specific issue. The last 2 years of tenancy in which Carol is seeking 50% of a rent reimbursement, that tracks the same period of time where the unit was affected by the flood caused by the shampoo bowl in mid-2021. So again, causally, the flood is certainly a major factor in those last 2 years. We don't believe that 50% is warranted. Additionally, I know now, having had the opportunity to read Jackie's brief, which was excellent and detailed, although some of the facts are certainly interpretive compared to what I've learned from my client. One of them being that Carol's position is she was going to have stayed in the unit for 5-10 years more. However, because of their friendship, Olivia knows that in fact that's not true at all. Carol always wanted to get out, having nothing to do with harassment. She was in a 1-bedroom with her adult daughter. She moved to a 2-bedroom in a different area of town that she perceived to be safer. And the rent differential is being made by comparing the rent in a different neighborhood for a 2-bedroom to the rent that Carol was paying in this rent-controlled unit in a different neighborhood in Oakland. So the math, we don't agree with the math on the rent differential. We also certainly don't agree that it should be multiplied by the 5 years, because Carol had no intention of staying in this unit for 5 years, let alone 10. With that said, it is early in the day. We are going to increase our offer of $50,000 by $25,000 to $75,000.
Okay, and I thank you for the feedback. As I recall on the rent differential, they are applying 200, oh, sorry. I believe that your client Olivia had the apartment vacant for 3 months after Carol and her daughter moved out, and then was able to rent it for $200 a month more, right? So your contention is they should use the actual higher rent of $200, not the $535 fair market value.
Debra, you've got it exactly right. And that 3 months of vacancy was also created because Olivia allowed Carol to leave when she found this bigger place in a different neighborhood without giving her the 30-day notice required under the lease.
Okay. Well, I have concerns about other issues, but I will talk to you when I come back into the room next time. Thank you.
All right. Thank you.
So now I'm going to go back into Jackie's room.
Hello, Deborah.
Hi, Jackie. So sadly, it seems that we are engaging in what I'll call tit for tat, or the haggle waggle negotiations, where you two are kind of climbing around the same amounts, which isn't very helpful. So Erin's new offer is $75,000. And as you recall, your last demand was $950,000. I'm hoping that you would consider, given some of the problems with non-covered items and reframing some of the harassment, that you could lower it maybe to what, $750,000?
You know, I think that I wanted to point out that I think the refund of rent should also be trebled, because the Oakland Tenant Protection Ordinance allows for trebling, and there's various types of landlord harassment, but failure to repair is type of landlord harassment. Discriminating is a type of landlord harassment. So basically all of the things that were happening during the tenancy that account for a refund of rent also are violations of the tenant protection ordinance. So I think there's trebling there. I understand that there's gonna be arguments about coverage there, but it increases the risk in the other room. You know, I think initially I was considering just doing a tit for tat to 900 to 900. But for purposes of time of today, maybe we skip the last tit for tat line and I'll go to, you know, I don't want to go quite as low as you're saying, Deborah, because I still am doubtful that they've come with like real money here today. And so, you know, I'll move to 775, but I really would like the message conveyed that I really need the defense to be above 600 ultimately. And, you know, sometimes I don't come out with that and tell a mediator that, but, you know, I trust you. You've done really good work, and I know you're not going to use that in a harmful way. You'll use that to get both the parties to a reasonable place. So we'll move all the way down to 775.
All right, thank you for that. So now we've had the passage of time, and we have the $775,000 lowest demand and the $200,000 offer after a few more rounds. So now I want to talk about breaking impasse. I need to break impasse here because the personalities, as we know, drive so much of the mediation. And it's my job as a mediator to educate counsel and the party about the risks involved. So I have gone into Erin's room again now to talk directly with the landlord, coverage counsel. Well, they're not there. More defense counsel. And it's chaos in her room. I've discussed the allocation between mold and non-mold, layers of coverage. At least I've tried to talk to Olivia since she hasn't had counsel there. And settlement. I've warned Olivia not to derail the mediation and potential settlement because I think the risks of the upcoming trial or the BATNA are great for her. So I've switched from facilitative mode to more of an evaluative mode. And I've also gone into Jackie's room and I've discussed with Jackie and her clients that the inflated emotional stress damages, I think they were like $900,000, may lead to an impasse. I've also discussed how to measure the fair market value of their rent. It was vacant for 3 months after they moved out, and it finally rented for $200 a month, not $535 a month more that they had in their brief. Lastly, we discussed the addition of the professional shampoo bowl that may have caused the flooding and the need for hundreds of thousands of dollars of repairs in the apartment. So now we're going to go to brackets. To break impasse and move the parties to a more realistic settlement range, I'm going to ask each of the parties to consider a bracket. I think you have up there where they're going to consider. So I'll start first with Jackie. Hi, Jackie. I know this is getting late in the day and you're very frustrated, or at least your client is, and I appreciate staying with this. I think because you, the parties are so polarized, we might consider using brackets to get to the sweet spot so we can get this done for you. In other words, right now you're at $775,000 and the defense has offered $200,000. That's a pretty wide spread. So maybe you can come back after talking to your client and tell me, we would consider going to X if they had offered Y, something like that. What do you think?
Okay. I think that's a good idea. I think I'd be remiss if I didn't, in response to some of our earlier conversations, and checking back in with my clients, if I didn't mention, and maybe this is helpful to you to bring to the other room, I'm not sure, but I think there's a few things being said in the other room about my client wouldn't have stayed there a long time because it was a 1-bedroom and she moved to a nicer neighborhood in Oakland. The reality is that my clients were forced out. Carol is a single mother who's supporting her disabled daughter. She's a hairdresser still trying to build up her business post-pandemic. She does not have the money to be spending more on rent. So she would not have voluntarily chosen this place if she could have stayed in Olivia's building. This was basically what she could find during a very tight rental market. Her clients are closer to the property that Olivia owns. Her daughter's doctors were within walking distance to where the old building was. And also, it may seem unconventional, but Jessica is disabled, and part of what eases her pretty severe anxiety is she shares a room with her mother. So even in the new 2-bedroom, they're sharing a room. The jury will see that, they will testify to that, and they are in a 2-bedroom, but the second bedroom is basically being used as kind of a school place for Jessica. It has a desk, it has storage. It's really, they didn't need a bigger place, and they would have been happy to stay in that unit, but for the habitability and the harassment. And I know that Olivia says she only re-rented it for $200 more, but we've hired a fair market value expert. That's where our number comes from, $550-ish or so. And I think that expert testimony will hold up at trial. And that's what she would have had to pay to rent the same unit essentially down the block. So all that being said, I like the idea of this bracket. Hopefully it encourages them to come back with, to accept it or come back with a reasonable bracket.
So your bracket of 600 to 750, is there any way you might consider going down to, for example, 500, making a little bit wider bracket?
At this point, I don't think I have authority to do that. I will talk to my clients about some of the things we just talked about that you told me about in terms of the other side's perspective and collectability, and the realities of going to trial. So, we can discuss that, but right now I only have authority to do a bracket of 750 versus 600.
Okay. And I appreciate all you've shared with me. I really like your clients, and I feel badly for Jessica. That's a disability that would make it really hard for her, particularly when you had so much going on in that apartment complex. Mm-hmm. I think that was due to the tent encampments and fires and so forth. So please let her know that I feel for her. I'm glad that they're in a better situation now. And thank you. I'm going to go talk to Erin.
Great. Thank you, Deborah.
Thank you. Erin. Hi there. Well,
Hi,
we've gotten
Debra.
later
Welcome back.
in the day. Thank you. We've gotten later in the day, and it looks like we are kind of in different camps, if you will. So I thought we might try the idea of brackets to see if we can get more into a sweet spot because we're too polarized. And Jackie liked the idea. She came up with a bracket of if you had offered 600,000, they would have been at 750,000. So I don't know how your clients feel about that bracket, or I would invite you to come up with a bracket of your own.
I think brackets are a great idea. And I also want to acknowledge you for the help when Jackie sent in a message of this case has got to have a 6 in front of it, or we're not going to settle today. As you saw, that caused some concerns in my room. And so helping to talk through that in the room was important. Obviously, I've spoken on Olivia's behalf directly, but I cannot advise her on coverage issues. So she needs to know about her own personal potential exposures, as does the entire room, because again, we have a trial in this case coming up in January. And so the costs are certainly going to ramp very soon. And that's something in the BATNA my clients have been advised about, and you emphasizing that again was very helpful. So we do want to commit to being here, to seeing if we can get this done. I appreciate the bracket proposal. Again, I think we have a real difference of opinion on valuation. I know Jackie has an expert who's going to testify about rental differential, but the relet price of the unit is excellent evidence that my expert will rely on, as well as to show that Olivia's motive wasn't to push out Carol and Jessica so she could raise the rent to some astronomical level. Even if Jackie's expert is correct, then Olivia was reletting the place for below market value, which certainly undercuts their entire theory about harassment and motive on behalf of Olivia. The last piece that I'll say when I offer my bracket is the $900,000 of non-economic damages simply is not supportable, particularly here when we don't have any medical records at this point in the case of personal injury. In the jury summary and verdict summary and settlement summary that I provided you as part of the mediation for Alameda County, we see that without that component, damages for non-economic come in around $30,000 to $40,000. Right here, we have $900,000, which also includes the trebling. With that said, let's get down to business with the bracket and try to keep this moving. I would go to $300,000 to $500,000 in response to Jackie's last bracket.
Thank you. I just want to make sure of one thing. When you give a bracket of 300 to 500, that means that your client, Olivia, has given or has the funding for or settlement authority to cover 300,000 to 500,000, correct?
Debra, that is correct. And you can also be reading into our middle point of where we would like this to end.
Well, I appreciate that. Thank you.
Yes.
All right. So now that I have both brackets, I realize that the way this is most likely going to settle is through a mediator's proposal. So I go back and I want to explain to Carol directly. Apparently, she wants to net 400,000, and I know from her counsel there are $10,000 in costs and 40% contingency fee. So there are risks going to trial. Moreover, as a hairdresser, she'll likely have to sit with Jackie in the courtroom for at least 2 weeks, missing her income. And her daughter has severe agoraphobia, so there's no way it would be impossible for her to stay at trial. For Erin, I go back into her room and the defense is scoffing at paying anywhere over $500,000. I discussed with the defense, particularly Olivia, that the cost of going to trial, including paying attorney's fees, will be prohibitive for her. She just can't afford to do that. And I also discussed the weaknesses in their case. So in the end, I have to think what is the most that I can get the defense to pay and the least then that I can get the plaintiff to accept. And so I have to look at the stretch. In this case, because I've had some conversations with both counsel, I asked Jackie if she would consider, remember, her bracket going to 500, and she assured me twice now that she had to have a 6 in front of it, 600 or up. I've talked to Erin, who said that, you know, they're hoping, read between the lines, they're hoping that 400 is the issue. So between that and coming here to tell you about my mediator's proposal, I've gotten the idea that it will have to be close to the 6, but it can be right under, because if it's at 6, Erin's room may say no. So my mediator's proposal is $575,000. I usually give both sides 1 hour, since we've been in Zoom land or now in person, to give me a response, unless I hear from counsel, particularly claims reps, who need maybe a week, maybe 2 weeks more for stated reasons to get coverage or to round table and go back up to headquarters. So in this case, my mediator's proposal is $575,000. They have 1 hour to consider it, and we'll see what all of you put in the chat. What is your decision? Thank you very much for joining us today in our mock trial. So please look in the chat room at your mediator's proposal. Katie, take it away.
Thank you, Deborah. Thank you, Erin, and thank you, Jackie. We are here near time. I did just launch a poll into the audience. We have 2 questions on that poll. Should the plaintiff accept the mediator's proposal, and should defendant accept the mediator's proposal? So please let us know what you think there. I'll close the poll here in just a couple of seconds, and our speakers can give their thoughts on if they would take this deal or not.
Erin, you go first. Oh, I'm sorry, Jackie, you go first.
Sure. So, without Erin knowing, I would recommend to my client that they accept this deal, this mediator's proposal, for a few reasons. You know, one, I think it is a good amount in terms of their damages. You know, there's always a possibility of getting more at trial, especially on the emotional distress side or factoring in the attorney fee award. But I have one client who has agoraphobia, which is a fear of strangers, and severe anxiety. So going to trial is going to be very difficult for her, and her not being seated there through trial is not going to be a good look for the jury. So I've tried to downplay that in the mediation, but it is a real concern in my room. And also, Carol is economically struggling. She's a single mother, and to her, money now versus going after Olivia and trying to collect the uncovered claims for possibly years down the line is not something that she is interested in doing. So money now is worth more than money later, and certainty now is worth a gamble later. So those are some driving factors in my room that I would be discussing with my client and be recommending they accept this amount.
So Jackie, interestingly, 95% of the audience agrees with you. Erin?
Yes, and in the time we have, I'm also going to have recommended, and my group will have agreed to accept the mediator's proposal. So thank you, Deborah. And the main reasons there are, this is all going to be funded by insurance. And as we've identified, Olivia had a lot of potential exposure here if this did go to trial. In addition to that, although I tried to underplay it, Olivia also had some credibility issues. Now, while it was certainly a bad fact that Carol had installed the shampoo bowl resulting in this flood, because of their underlying close friendship, it does make it more difficult to understand how Olivia had no idea that that was in fact occurring. That was a risk in a discussion that I had with Olivia, because I'm having 2 conversations, the one with Deborah, where I do need to use some candor, but also puffery, as we all do in negotiation. And then the conversation that I'm having in my room with my clients, where I'm very, very realistic with them about the possible exposures and the risk to them. So in accepting this mediator's proposal, similar to Jackie, we buy ourselves finality and certainty for a number that the carriers can also digest and stomach.
73% of our audience agreed with you.
Side. So we are at our 1 o'clock time note here. So folks, if you do have to head back to your desk and leave for the afternoon, you will receive full CLE credit. I understand that our panelists have offered to give us just a couple of minutes to answer some of the questions that have piled up here. But as you leave the webinar, you will be directed to a brief survey. We would really appreciate if you take a couple of minutes to give us some responses there, some feedback for our speakers, and most especially any ideas for future programs that you would like to see. We always strive to present content that you're actually interested in learning about for these CLE credits. So I do have a few questions here that I would love to pitch to you. One clarification question about the term trebled, which you kept referring to as far as the damages were concerned. What does that mean? And is that because of punitive damages, or was that something local law? This was based in Oakland. Can somebody comment on that?
Yeah, I can handle that one. So treble damages are where the law allows for economic or non-economic damages to be tripled. Don't know why they didn't just call it triple, but they put an E in there, so it's treble. And that is based on statutory, a violation of a statute. So you have a statutory cause of action. In this case, it was the tenant protection ordinance or the tenant anti-harassment ordinance that had the ability to triple the economic and non-economic damages arising from that violation. Just generally, since I know a lot of you practice statewide, the California Tenant Protection Act now, as of April 2024, has a trebling provision. So the judge, not the jury, is the one that would triple the damages essentially at the end of the trial. And it's separate than punitives, so it's different. It's a statutory damage, and there's some case law, Kelly versus Yee, that distinguishes statutory damages and punitive damages. And so I will often be arguing in a mediation that if the policy doesn't explicitly exclude multipliers or statutory damages, it only excludes punitives, then actually the carrier should consider those being covered. That's a big contentious issue that I'm sure Erin's side does not agree with.
Yeah, it's a great point, Jackie, and thank you for that question, because it certainly does come up. And because the tripling or treble damages are more a penalty in nature, similar to punitives, although not a distinct category from punitive damages, often the argument will be made that those aren't covered. And the rub in sometimes making the arguments about tripling damages is that there has to be some increased showing of gross negligence, for example, intent in some instances. So as Jackie is making those great arguments, at the same time, that could be getting out from under some potential coverage. So there's a real push and pull there with trembling of damages. A dance, shall you say, between
a dance, yeah. And in some, sorry.
Go ahead.
Oh, and in some jurisdictions, the statutes allow for automatic trebling without a showing of bad faith. So like in San Francisco, it's automatic. In Oakland, under the just cause ordinance, it's automatic for economic damages like rent differential, but then to get a trebling of the emotional distress, like in this case, I was arguing those pretty hefty damages should have been trebled. You would have to show a knowing violation or a bad faith violation. And so we're doing that dance with insurance, at least on the emotional distress trebling.
I have a question for Debra here, kind of about your mediator's number train of thought, which some of our attendees here thought was very fascinating to follow, which I agree. They had a question, you said that you weren't really considering the midpoint number between the two sides, rather using some other figures. Do you ever keep in mind the midpoint number? How do you use the midpoint number?
Always. Every participant, lawyer in the room, mediator is constantly aware of the midpoint number. Absolutely. But I think that anyone could just give a mediator's proposal with a midpoint. That's easy. What makes it more challenging and more effective in settling a case is to figure out not the middle point, but could you go a little higher? Could you go a little lower? And in this case, Jackie told me twice and more times back in the room, she would not take anything under 600,000. I've mediated before with Jackie, so I know when she's, being straightforward with me. And so I had that in my mind that it's got to be close to 6, which is why I came up with 575. I knew from Erin's room that while she would like me to have come in at the sweet spot of 400, her middle number, she also pointedly had given me a high of 500,000. So I had asked a few questions of each one gently to see if they would give me, if Jackie would drop lower to 500, if Erin would go up. And I knew from the room that Olivia needed it to get done. She was in the 5 range, so 575 seemed like that would be the number. And typically now when I make a mediator proposal, I've already somewhat tested it in each room to make sure that it is going to be a good number. And that's taken a little bit of, I have to say, mistakes along the way and experience.
I think maybe just another question in the interest of time and cognizance that all of you do have other things to do this afternoon. I know Jackie's actually in a real mediation today. So maybe a little bit of a question about mediation briefs. You did encourage both sides to exchange their portion, even with Erin putting in a confidential supplement. And somebody commented that there wasn't much legal analysis in those briefs. As a mediator or as, the counsel at hand, do you find it helpful to have that legal authority for claims and defense? Are you interested in providing that to your mediator? As a mediator, do you care about seeing that?
I'm just going to jump quickly. If it's an area that I have some subject matter expertise in, which is somewhat broad, I don't necessarily need the law. Everybody always puts it in there. For purposes of our mock mediation, we did not, because we had to keep the factual portion to a page or 2 or 3, which was hard enough. But typically, I like to see the fact pattern being longer, photographs put in, than necessarily the law, unless it's in a complicated area or unusual area, and then the law would be helpful. But in this area, landlord tenant, I think the 3 of us involved in the mock mediation know the law pretty well. So I would expect in a normal mediation brief just to have maybe a half page of the law or referencing each item of damages to the particular statute or law. Jackie, Erin?
Yeah, this brief was not reflective of what my normal briefs look like. They're usually about 15 to 25 pages, depending on how many pictures are in there. They also include a chart summarizing each line item of damage with citations to the law supporting that. I think that's particularly helpful in an area of law where there's a lot of statutory damages and penalties, and seeing how that all adds up. So I usually do have quite a robust section on the law. And often the mediators probably don't read that section, but sometimes I put it in there because I have insurance adjusters or defense counsel even that may not have practiced a lot of landlord tenant law. And often the actual client might be reading it, the defendant might be reading it. So I think it's important for them to see the law and the exposure as well. And I'll do, all the claims covered and uncovered.
And I completely agree with what Debra and Jackie had said. For this exercise, I think our briefs were just focused on the facts, really, which is not standard for us. I will certainly include the important law, as well as I think photographs, to Debra's point, are very important, as well as even communication exchanges, if they're right on point. Because as we know, notice is key in many of these cases. If you have important reports, for example, mold clearance reports, or in our mock case, I would have included the plumber's report when he responded after this shampoo bowl. And to also have some of your key experts lined up before the mediation. We did the mediation call, but the real work starts long before Jackie or I are talking to Debra. We're retaining experts if the case needs require it. We've done a lot of discovery. We've taken depositions, and all of that is the pre-work you want to do to set yourself up for success in the mediation.
Well, thank you all. I think we will wrap it up here. Just about 10 10 minutes of questions there. So thank you very much for spending some additional time with us answering those questions. And thank you so very much for your time preparing for today's mediation session. It's very insightful. I especially liked hearing about the pre-mediation calls there.
Thank you, ADR, and thank you, Deborah. I think that this mediation was very truncated, but is pretty reflective of Deborah's ability to settle cases, and reach out to me if anyone has any questions or wants to follow up with something.
Yeah, thank you, Katie, Deborah, ADR Services, for hosting us, and also wonderful to work with you on this, Jackie. Same, reach out to me with any questions. And Deborah, thank you for helping us get it done in 1 hour.
Yeah, that's.
I can't say all in 1 hour.
Thank you to all for coming in our audience to participate, and for Katie to suggest this topic. I think in the landlord-tenant mediations that I do, this is one where the facts were exhaustively reviewed by both sides. And so that was a pleasure to read. The more I have from the mediation briefs factually, I think the more helpful I can be in helping to resolve the case. So thank you, everybody.
And I think the mediation briefs are in the chat, right, Katie?
They are, yes. And
if
you'll
anyone
also
wants to look at
receive
those.
another copy of them with your certificates, which will follow within the next week over email. Keep an eye out for those. And if you have a moment to please fill out our survey when the webinar ends, we would really, really appreciate any of your feedback. Have a wonderful afternoon, everybody, and thank you for spending your lunch hour with us. Bye-bye.
Thank you, everyone.
Thank you.
Take care.
ADR Services, Inc. has been your unwavering partner in alternative dispute resolution. But as the world changed, so did we. From virtual and hybrid hearings to our ongoing on-demand CLE program, ADR Services, Inc. continues to keep resolution and legal education at the forefront, woman-owned and operated from the start. There is someone for every situation. We are ADR Services, Inc.